Hello everyone, we are team No Joiners and today we will be presenting on Fairstone Financial Holdings Incorporation versus Duo Bank of Canada 2020. This case was decided by the Ontario Superior Court of Justice. It is a fascinating example of how unforeseen circumstances such as global pandemic interact with contract law and commercial agreements. Let's begin by outlining the key facts of the case. So we will now start by the facts, that is the introduction to the case. This case involves two parties, Fairstone Financial Holdings Incorporation, the plaintiff, and Duo Bank of Canada, the defendant. In February 2020, both parties signed the share purchase agreement, that is SPA, under which Duo Bank agreed to acquire Fairstone. The SPA included two important provisions: a material adverse effect, that is a MAE clause, an obligation for Fairstone to operate in the ordinary course of business. When the COVID-19 pandemic hit, Duo Bank claimed that Fairstone violated these provisions and sought to terminate the deal, leading Fairstone to initiate legal action.
Hi, good morning, Professor. I will talk about procedural history and judgment. First of all, the Fairstone took the case to the Ontario Superior Court of Justice, demanding that Duo Bank completed the excavation as per SPA. Nextly, Duo Bank argued that the pandemic caused a material adverse effect and the Fairstone's operational changes breached the agreement. Lastly, the court ultimately ruled in favor of Fairstone, rejecting Duo Bank's argument and enforcing the acquisition. The court ultimately ruled in favor of Fairstone, rejecting Duo Bank's argument and enforcing the acquisitions. The decision is significant for setting a precedent on how courts interpret contract during extraordinary events. Thank you. Now I will talk about issues in this dispute. First of all, this case focused on three key legal questions. The first one is, did the COVID-19 pandemic qualify as a material adverse effect? And the second one, did Fairstone breach the ordinary course convention by adapting its operations? And the last one, was Duo Bank justified in terminating the argument based on these claims? These issues form the basis of the court's analysis and ultimate decisions. Thank you.
Hi, my name is VIKRANT. Now I am going to start slide 5, holding decision. The court made three critical findings. The first one, the paramedic did not consist of material adverse effect under the SPA because such events were included by the contract. Second one, Fairstone operational adjustment such as adhering to health guideline did not breach the ordinary course requirement. And the third one, Duo Bank was not justified in terminating the agreement and was ordered to complete the acquisition. The decision reaffirmed the importance of fulfilling contractually obligations event during the unpredictable events like a global pandemic.
Good morning, Professor. My name is Gurdeep Singh and I am talking about slide 6, rational reasoning. The court's reasoning focused on three main points. First one is material adverse effect, MAE. The SPA explicitly excluded general economic or market conditions such as pandemic from the MAE clause. Since the pandemic affected the entire financial industry, it did not qualify as an MAE specific to Fairstone. Second one is ordinary course covenant. Fairstone's operational adjustments were reasonable and consistent with industry standards given the public health crisis. And the third one is good faith. The court emphasized that Duo Bank's actions lacked good faith. Contract law requires parties to act fairly and reasonably even during extraordinary events. Thank you.
Hello sir, my name is TUSHAR and today I will talk about key takeaways and this case provides several keys lessons. And my first point is precious drafting is critical for contract for terms like material and adverse effect to avoid disputes. And my second point is operational changes during crisis should align with industry norms and public health requirements. And my third point is courts will emphasize good faith and fairness with resolving contractual disputes, particularly in unpredictable situations like the COVID-19 pandemic. This way underline the importance of adaptability and clarity in context. If I talk about the COVID-19 crisis, provide an opportunity to reflect on what worked during the pandemic, what could have been done differently, and what innovation should become part and enhanced health information system in the future. Thank you, sir.
We now open for the floor to questions. Please be asked to about any aspect of the case. The suggested response is the first question about the pandemic didn't qualify as an MAE because the SPA explicitly excluded broad economy and events like pandemic. The second question is about the Fairstone's adjustments like reducing in-person services were necessary to comply with the public health measures and aligned with the industry standards. The third question is about the good faith played a critical role as a court found used bank state attempts to terminate the SPA opportunities and contrary to the spirit of the agreement. Right now, we will go to the conclusion. To conclude, this case highlight the importance of the clear contractual language, particularly the provisions like MAEs. It also emphasized that the reasonable operation adjustment during crisis as permissible if they align with the industry standards. Finally, the decision reinforces the principle of the good faith, showing that even extraordinary events like the pandemic don't excuse parties from fulfilling their contractual obligation. Thank you for your attention.